Now, parliamentary agents draft private member bills. That's bills sponsored by individual members of the parliament, while parliamentary council draft executive bills. Executive bills are known in the UK as government bills. So bills emanating from the executive arm of the British government are known as government bills. So parliamentary council draft government bills, while parliamentary agents draft individual or private member bills. As it stands today in the UK, if you are not a parliamentary council or a parliamentary agent, you cannot draft a bill that will be used in the British Parliament. Even if you are a QC, even if you are Queen's Counsel or now a King's Counsel, you will not be able to draft that bill because they are regulated. Now, what has that achieved for them? Standardization of their bills. There is a standard format that their bill follows. Then the use of plain language. The bill is not riddled with Latin maxims and legalese. So that is the history of legislative drafting, which over the years has evolved into what we have today and having it as a distinct area of practice. As we make progress in this training or course, we will get to talk about plain language drafting specifically as a topic. We have it in the timetable, so we will further understand where we are coming from. We will look at topics like gender neutral drafting. That will also take us a little back to the history. So having said that, we moved to, okay, Prof, sir, you have your hand up.
So in 1869, the Parliament of the UK set up Office of Parliamentary Council. Then in 1919, the USA, the Congress of the USA also established by law, theirs was by an act of parliament. They established what they call the Office of Legislative Council. You know the difference? One is parliamentary system of government, the other one is legislative, because they are presidential system of government. So the US, which is presidential, set up, established by an act of parliament, the Office of Legislative Council, 1919. You remember the US was also colonized by the United States. So this is something you need to know. The improvements over the years in the area of legislative drafting. So the US has a law, 1919, it's called the Office of Legislative Council, which is the lawyers who draft for their Congress of the US. So they have in the Senate, we did a study visit to their offices. They have the Office of Legislative Council in the Senate, then they have the Office of Legislative Council that the US has made in the area of legislative drafting. It is a crime in the US to draft a law that is not drafted in plain language. In 2016, during the administration of Obama, they passed a law called Plain Language in Legislation Act 2016. The purpose of that law is every legislation must be drafted in plain language. Plain language means a language that the layman can understand. Remember what led us to the establishment of the Office of Parliamentary Council? Because lawyers were drafting in legalese. Legalese is legal jargon, which only lawyers can understand. So to defeat that, to combat that problem, the US has passed a law called Plain Language in Legislation Act 2016, which says that if you are a lawyer, you are drafting laws, you must draft in plain language so that the common man can understand. It is a crime in the US not to draft in plain language laws. And no person in the US, the Supreme Court of the US has held that no person in the US can be penalized, can be punished because a law is drafted in a legalese, in a language that the ordinary man cannot understand. You cannot punish them. The US Supreme Court calls it Caligula law. Caligula is a Roman emperor that used to write laws in tiny handwriting and put them at the top of the entrance of the city of Rome. And yet he will penalize people for not obeying the law, which they could not read. So the US Supreme Court has said, if you draft a Caligula law, that is a law that is not accessible to the people. Access means the language is not accessible. You cannot punish people for disobeying a law that they did not understand. So these are developments in the area of legislative drafting, which I thought we should bring to your attention. Thank you.
Thank you, Prof. Thank you, sir, for that incisive contribution. We are looking now at the difference between legislative drafting and other areas of drafting or general legal drafting. Now, we define legislative drafting as the process of reducing the intentions of the legislature into writing. Whatever the legislature thinks or conceives that is in the recesses of their mind, the process, the act of reducing, of concretizing it, making it concrete and tangible, is through writing. And that writing process is called legislative drafting. We also say that legislative drafting is the process of producing legal instruments or documents used in legislative business. That is the major difference, because legislative drafting focuses on drafting documents that are used in legislative business, documents such as bills, such as motions, order paper, compendium of financial estimates, brief of arguments, bill analysis, and a host of them. That is what legislative drafting focuses on. Whereas legal drafting generally has different areas of law that it affects. You can be drafting contracts, you can be drafting instruments of transfer or instruments of title, you can be drafting arbitration settlements, you can be drafting even processes to file in court, litigation processes, you can be drafting your originating processes, documents you use in courts. But for legislative drafting, it's strictly focused on legislative drafting. One is that you improve your drafting skill. That is a benefit, and that having an improved drafting skill will automatically reflect in your processes. Is that you can become a lecturer, like our dear prof here. You can become a lecturer in the university teaching legislative drafting. In fact, some universities in Nigeria are beginning to take up legislative drafting as a course at undergraduate level, and some universities are also setting up legislative drafting clubs. I have had the privilege of being directed by Prof to facilitate for one of such clubs. So it is really evolving and spreading too. You can be a lecturer, you can be an author. I told us Prof has written over 10 books on this subject area. You can be a consultant, as Prof is also. He's one of our living examples that we can easily identify with. So you can be a consultant for the National Assembly, for the State House of Assembly, for the Ministry of Justice, whether state or federal, for the Law Reform Commission. You can also consult for multinationals. He has consulted for EU and is currently doing that. His stay at Lesotho at the moment is on account of a consultancy service funded by the European Union. You can consult for the United Nations, you can consult for the World Bank, you can consult for other international NGOs. You can also stay as a private consultant. You can be employed. All of what I have mentioned, consultancy for federal and state ministries, but you can also be a staff of the National Assembly. You can work in the Directorate of Legal Services at the National Assembly. You can work at the Federal Ministry of Justice. They will just put you in the legal drafting department where they have a subunit for legislative drafting. So the career prospects is enormous, and you determine your fee in this area of practice. More so, it is not a skill set that is readily available. Even here in Nigeria, a few lawyers, there you can count on your fingertips who are trained experts in this area of drafting, apart from civil servants who, by way of learning, they are posted style of drafting with civil law style of drafting. And that's what we get to see some of the times you pick up a legislation as you're reading. For example, if you see a purpose clause in a civil law jurisdiction, if you any law in Nigeria that has purpose clause, it's an error from the drafts person. Now, take note of what I said. From the drafts person. I didn't say from the draftsman. I didn't say from the draftswoman. That is gender neutral. So when we do our gender neutral drafting, we will come back to this. So purpose clause is strictly for civil law jurisdiction. Have not undergone this training. They do not know. So they use the existing precedent they have used over the years. And a key challenge is that you even find it difficult to correct them. Because if you say, no, this is not the right way to do it, they will antagonize you and say, we have been doing this thing for the past 10, 15 years. You have been making a mistake consistently for 20 years. That does not make it right. The best thing to do is simply to turn around and do the right thing. But unfortunately, it is not so. So part of your responsibility as you go through this course is to draft functional bills that conforms with global standards, bearing in mind the different drafting styles of each jurisdiction. Okay, so any questions so far? Any need for clarification? Any contribution? Hello, any question? Okay, Mr. Oscar, your hand is up. Hello, Mr. Oscar, your hand is up. You raised your hand. Okay, Honorable Kolade, sir, you have the floor. Honorable Kolade, ask your question, sir.
Thank you, Mr. Lecturer. You mentioned the areas of coverage of legislative drafting, including motion bills. I'm not able to get the other ones you mentioned.
Okay, I mentioned documents that are used in legislative houses, which are usually drafted by legislative aides or assistants to the honorable members who are, in quotes, supposed to be professionals. Okay, Honorable Kolade, sir, you have the floor. Honorable Kolade, ask your question, sir.
Thank you, Mr. Lecturer. You mentioned the areas of coverage of legislative drafting, including motion bills. I'm not able to get the other ones you mentioned.
Okay, I mentioned documents that are used in legislative houses, which are usually drafted by legislative aides or assistants to the honorable members who are, in quotes, supposed to be professionals. Now, such documents include motion, bill, compendium of financial estimates, bills, brief of argument. I will explain each of these documents. Brief of arguments, bill scrutiny reports or bill analysis reports. Now, motions are applications before the House. They come by way of motion. The way we have motion that we present before the courts, but the format is not the same. Now, if there is an urgent intervention the House wants to undertake, or an honorable member wants the House to undertake, which does not necessarily require to go through the rigorous process of bringing up a bill and passing the bill into law or an act before that action should be taken, the honorable member brings that application by way of motion. For example, if there is an erosion that is going on somewhere, or let me use what is currently happening in the US and other parts. Now, if the firefighters, there's a shortfall in the National Firefighting Service or whatever name they call it, and the Parliament or the National Assembly wants to do quick employment to have more hands to assist in arresting the fire, instead of going through the normal procedure of calling for application, going for interview and all that, an honorable member might bring up a motion to say, we are facing this challenge. I am moving this motion for the House to circumvent to cut off the natural process, or maybe 3-4 months period of employment procedure. Let us engage able-bodied young men between the ages of 20 to 30 and give them 2-3 days orientation in firefighting. Let them go and support the firefighters. That is motion. So the House may move, those in support say aye, those against, and the ayes will have it, the motion will be passed. The House will now advise, or rather, the House will now tell the minister involved in charge of that sector to do recruitment, but cut the long procedure. So that is an intervention by way of motion. Now, if a minister is also going beyond his powers, or there is need to ask a minister to come and explain for what he has been doing that is affecting the generality of the people, a member can move motion and say, we want this House to invite the Minister of Finance to come and explain to the House A, B, C, D, why he's bringing out so and so policies. The motion will be passed, the minister will come. Instead of waiting to do a law, pass a bill into law, that is motion. Then we have bill analysis reports. When bills are submitted to the House, or when bills are sponsored by an honorable member, before the bill is argued on the floor, the bill is circulated among members who come ready to either support or oppose the bill. Now, before the day of coming to argue that bill, the honorable members will scrutinize the bill. Remember, they are not learned people. they will give those bills to their legislative assistants, who are most times lawyers, who are supposed to know the legal implications of the bill. Those ones we read through the bill, they are armed with knowledge of the Constitution. They are also armed with knowledge of decisions of superior courts, particularly the highest court of the land, which is the Supreme Court, on each subject matter. They also know where to do further research to know the position of the law. Those ones we analyze the bills and bring what we call bill scrutiny reports or bill analysis reports and give to their principals to say, sir, you have to support this bill because of ABC, or sir, you do not have to support this bill because of ABC. And the example I usually give is this. If an honorable member comes up with a bill that seeks to create a law that provides that every government job opportunity, 75% of that opportunity should be given to women, and he's doing it in good faith, believing that he's pushing women empowerment, if you bring that bill up for bill analysis, one of the first things you will flag is the constitutional right against discrimination based on gender or sex. So by the time you say give 75% of job opportunities to women, you are discriminating against the male folk simply because they are male. So that is bill analysis. Then we have brief of arguments. Every bill is supported by a brief of arguments. Now, the brief of argument is the argument of the sponsor of that bill in support of the bill. So if you bring up a bill and you will defend that bill, present it at the floor of the House and argue, everything you have to say in support of that bill, you put it down as a brief and share it among your colleagues. It is usually not the honorable member that does this brief. It is his legislative assistant that writes the brief of argument for him. So that is your work as a legislative drafter, to write brief of arguments. Compendium of financial estimates is 1 year budget that is supposed to be attached to any bill seeking to establish a federal agency, federal government agency. So if you are seeking to establish a federal government agency, by provisions of the standing rules of the Senate, you are supposed to accompany that bill with a document called Compendium of Financial Estimates. It is 1 year budget of what it will cost the government to establish that agency. Now that your budget will capture the office of the new agency, the personnel, manpower, how many persons should be engaged initially, the operational vehicles. You will talk about up to stationaries, everything that is required to run that office for 1 year. The salaries of those personnel will be captured for 1 year. Then you attach it. Who does that? It is not the honorable member. It is his legislative aid that will engage the relevant professionals to get these documents ready and draft. So as a legislative drafter, these are different job specifications for you if you are engaged with an honorable member as a legislative assistant. These are some of the terms of reference or job prescription you'll be required to carry out. So those are a few of the documents. Honorable, does that answer your question, sir?
Very well, thank you. Very clear.
Thank you very much.
Thank you.
Mr. Julo Emmanuel, your hand is up. You have a question?
Yes, sir. Good afternoon, sir.
Good
Please,
afternoon.
I have a question, sir.
Thank you.
Hello, sir. Because I see that time is almost over, and I want to rush the question to the answer. The question is that, please, what is the difference between legislative drafting and a bill? the bill that they used to pass in the National Assembly or the House of Assembly. Please, what is the difference? That is first question, sir. Second question is that, please, who are the people that are authorized to draft a bill, to go into legislative drafting? Is it personal individual or a corporate organization or a government official or a kind of establishment corporately, or a personal individual like myself? Maybe like you now, for instance, as you are an expert in legislative drafting, can you draft a legislative drafting personally and present it and for it to be recognized officially, sir? That's my question. Thank you, sir.
Thank you. Brilliant question. Firstly, you have gone ahead of us by taking us to a topic we have in our timetable, the process of bill making, the process of lawmaking, rather, moving from a bill to becoming a law. So, firstly, the difference between legislative drafting and bill making, that's your number one question, right? Okay. Now, legislative drafting is an act, is the process of drafting bill, the way and manner you draft a bill. Firstly, Mr. Ajulo, confirm to me that you are a lawyer, please. Are you?
I am a law student presently. I'm not a lawyer yet, but I'm an LLM student. I'm an LLM student of the National University of Nigeria, sir, but I'm preparing for law school presently.
Awesome. Okay, good. Now, your question is rightly situated. At your level, you can ask that question. Because if you were a lawyer and you ask this question, I'll have a problem with you. Okay, so legislative drafting is the act, the process of drafting bills. Now, bill itself is a document. A bill is a document. Let me just take any bunch of documents here, a bunch of paper here, and cite as an example. Can you see this? This is a process. This is a legal process. Now, bill, this is a document. This is a bill, for example. But this bill is a proposal. It is a proposed law. It is not law yet. This bill is a document we are presenting to the National Assembly.
Okay.
An idea that we have reduced into writing to say, National Assembly, there is need for us to establish an agency called Federal Road Safety Corps. Their duty should be to regulate or control vehicular movement on the road and organize traffic and ensure that there is reduction in accidents, and also ensure that vehicles that are moving on the road are roadworthy, they have proper vehicle papers and all that. And they consider it as, okay, it's true. Because we do not have road safety, people are driving recklessly on the road. Okay, we should establish road safety to give us a driving code, how people should drive and all that. Now, they come to the National Assembly and put it forth. If the national members of the legislature, if they agree with the sponsor of the bill and say, sir, your idea is good, we agree. That is when you hear those in favor say aye, they will say aye. Those against say nay, they will say nay. You hear the ayes have it. We will talk about the process of lawmaking, but I just need you to understand that a bill is a document, a proposal of law, a law that is proposed to the National Assembly to say, make this idea, make this suggestion, pass it into law. Once the bill goes through the different stages of lawmaking, which culminates in presidential assent, and the president puts his signature on it, it becomes law. It becomes enforceable. A bill is not enforceable. A bill has no force of law. But when it is passed into law, either as an act at the federal level or law at the state level, it now acquires a force of law. That is when somebody can be punished because the person did not do what is stipulated in the law. At that time, it is no longer bill. As a bill, we call each of the lines or sentences or thoughts or ideas or each of the paragraphs, we call it clause. Clause